Disqualification of Judges. John P. Frank, Indiana University School of Law. The Yale Law Journal, Volume 56th of April, 1947, Number 4. Disqualification of Judges. The recently published statement of Mr. Justice Jackson criticizing Mr. Justice Black for participating in a case argued by a man who 20 years before had been Black's law partner has brought the subject of judicial disqualification sharply into the focus of public and professional attention. Although Justice Jackson's views on the subject are not at all points clear, his statement shows an enormous difference of opinion in the Supreme Court on the subject of disqualification of its members. This article undertakes to survey the present American disqualification practice, to study its origins, and to explore the support for the varying views on the immediate subject of justices and their ex-partners. In the preparation of this article, an inquiry has been submitted to the Chief Justices of the various states and to judges of each Federal Circuit Court of Appeals to find out from appellate judges themselves when they disqualify, particularly in situations which may not be reflected in cases or statutes. The information obtained from the inquiry is utilized in sections of this article, but in order that the reports of the 39 participating state and federal courts may speak for themselves, the totals on various points are included in an appendix. The subject of judicial disqualification is one of consequence considerably broader than the superficial question of whether Mr. Justice Jackson is a patriot among sinners, as some imply, or a fool among wise men, as his critics may contend. The Jackson charge raises a substantial issue of whether judges should disqualify themselves in cases presented by former partners. There is no statute governing disqualification of federal appellate judges, and the various circuit courts of appeal judges must decide whether to follow Black's practice or Jackson's recommendation. State judges, too, to the extent that they are not governed by statute, must make the same decision. The federal district judges also must face the problem, for under the statute governing their conduct they may be required to decide whether hearing an ex-partner will constitute prejudice within the law. But the enormous body of disqualification law raises many questions quite removed from the extremely unusual ex-partner issue. While disqualification only occasionally attracts widespread public attention, as it did early in this century in Montana and very recently in Delaware, it is much before the courts and legislatures. Each state has some statutory or constitutional law on the subject, but all shadings of view on particular grounds for disqualification are discovered. The traditional grounds of disqualification for interest, for relationship, or for bias, set a general framework for most states, but within that framework there is room for wide variety. The divergences stem from two fundamentally different policies which govern the field. All courts want justice done, but the conflict of values comes over method. If disqualification of judges is too easy, both the cost and the delay of justice go out of bounds. If disqualification is too hard, cases may be decided quickly, but unfairly. Nowhere is that conflict of values more glaring than in the United States Supreme Court, where the cases are usually important. If a justice sits who should not, great interests may be jeopardized, but if a justice disqualifies who should not, vital questions may be needlessly left without authoritative decision. For under existing law, there is no procedure for replacing a disqualified justice of the Supreme Court even when his non-participation deprives the litigants of the statutory quorum necessary for decision. The polar views are expressed thus: by New Mexico, an easy disqualification state, our legislature in effect has said that a judge, even though blessed with all of the virtues any judge ever possessed, shall not be permitted to exercise judicial power to determine the fact of his own disqualifications, not because the judge in doing so would attempt to act otherwise than conscientiously, but because in their legislative judgment it is not fitting for him to make such an attempt, and it is better that the courts shall maintain the confidence of the people than that the rights of judge and litigant in a particular case be served. By Pennsylvania, a hard disqualification state, due consideration should be given by him, the judge, to the fact that the administration of justice should be beyond the appearance of unfairness. But while the mediation of courts is based upon the principle of judicial impartiality, disinterestedness, and fairness pervading the whole system of judicature, so that courts may as near as possible be above suspicion, there is, on the other side, an important issue at stake, that is, that causes may not be unfairly prejudiced, unduly delayed, or discontent created through unfounded charges of prejudice or unfairness made against the judge in the trial of a cause. The cases and statutes reflect, as might be expected, a mixture of these two views. All jurisdictions have some disqualifications and all draw a line where they believe the privilege of disqualification may be abused. Origins. The common law of disqualification, unlike the civil law, was clear and simple. A judge was disqualified for direct pecuniary interest and for nothing else. Although Bracton tried unsuccessfully to incorporate into English law the view that mere suspicion by a party was a basis for disqualification, it was Coke who, with reference to cases in which the judge's pocketbook was involved, set the standards for his time in his injunction that no man shall be a judge in his own case. Blackstone rejected absolutely the possibility that a judge might be disqualified for biases distinguished from interest. Pecuniary interest took many forms. A judge might be disqualified, as in Dr. Bonham's case, because he received the fine which he had the power to inflict, and the Mayor of Hartford was laid by the heels for sitting as judge in an ejectment case in which he was lessor of the plaintiff. A similar charge of interest arose where the judge's status as citizen and taxpayer of a unit of society might be affected by his decision. Thus, for example, in a case involving a pauper, a judge was disqualified for interest because the decision affected his taxes. The last mentioned cases went too far. For if judges were disqualified as taxpayers, some suits could scarcely be decided. Mindful of this difficulty, Parliament in 1743 provided that tax-paying justices of the peace might sit in these local government cases. Thus grew the modem rule of necessity, that judges should not decline to sit where no substitute was readily available. As Pollock later expressed it, the settled rule of law is that, although a judge had better not, if it can be avoided, take part in the decision of a case in which he has any personal interest, yet he not only may, but must do so if the case cannot be heard otherwise, and this remains American practice. A variant of interest is relationship, the problem posed where a judge participates in a case involving his relative. Oddly enough, the English courts, over-influenced by Coke, early held that a judge was not disqualified by relationship, but that a jury was. In the latter connection, courts were faced with deciding what degree of relationship necessitated disqualification, a problem which in its modem context remains as perplexing today as it was then. As was noted in 1572, all the inhabitants of the earth are descended from Adam and Eve, and so are cousins of one another, but the further removed blood is, the more cool it is. The line was drawn in that case at the 9th degree. In short, English common law practice at the time of the establishment of the American court system was simple in the extreme. Judges disqualified for financial interest. No other disqualifications were permitted, and bias, today the most controversial ground for disqualification, was rejected entirely. General American practice. The contemporary disqualification practice of both federal and state courts is broader than that of the common law. Not only has the principle of pecuniary interest been extended to keep pace with changing economic institutions, but relationship between judge and litigant, and a variety of other types of judicial bias have been prohibited in modern practice by the common law. Expansion of common law concepts has been brought about in the federal appellate courts, where no statute controls, largely through the exercise of their own discretion. In the Supreme Court, disqualification has always been the prerogative of each individual justice, and prior to the Jewel Ridge incident no member of the court has ever pronounced public judgment on the practice of another. From the beginning the practice seems to have been founded upon a mixture of common law notions, individual judgments of propriety, and practicability. While statutes do not explicitly apply to Supreme Court practice, the impulse of individual justices has generally been to adopt their principles. State judges have more often been subjected to limitations imposed by statute. In this respect older states have generally adhered fairly closely to the common law with only slight doctrinal and statutory variations. Newer states, on the other hand, have tended to adopt elaborate codes which fall into three categories. 1. Disqualification for specified grounds in addition to those recognized at common law. 2. Mandatory change of venue statutes, themselves of several distinct types, which often supplement the first method listed, and 3. Authorization of optional recusation, largely at the discretion of the judge. Interest. The current practice in cases involving interest is a logical extension of common law principles to cover modem situations. Thus it is now almost universal practice for judges not to sit in cases involving corporations in which they own stock. Zero doubts concerning the wisdom of this practice have been expressed, but have been quashed except in a few instances where the holdings are extremely small and the corporation so large that the decision is quite unlikely to be affected. Where the judge has an interest other than direct ownership, the issue becomes the remoteness of the interest. For example, where a judge is executor of an estate owning shares in a corporation appearing before him, is the interest so remote as to make disqualification unnecessary? 3. Analogous problems are presented where the judge is a creditor 14 or guardian 31 of a party, where his political career may be affected by an election fraud case. 11. Where he is an officer of a corporation defending or prosecuting the action. 11. And where a relative from whom he may inherit is a shareholder in a corporate litigant. 8. While disagreement as to the danger of judicial prejudice is understandable in the foregoing situations, the reasoning of the court which refused to disqualify a judge in a case against a cemetery corporation merely because his relatives were buried on its property seems incontrovertible. 39. The interest problem frequently recurs in cases where the outcome may slightly affect taxes or utility rates in the judge's home community. Under common law, as noted above, that circumstance would disqualify. But today such an interest is considered too remote to justify application of the principle, and courts have generally rejected the strict common law doctrine. Supreme Court justices have from the earliest times disqualified themselves in cases involving direct pecuniary interest. The practice was initiated in 1813 by Justice Livingston in Livingston and Gilchrist v. Maryland Insurance Company 41 and immediately followed by Chief Justice Marshall in Fairfax's Devise v. Hunter's Lessee 42 decided the same year. Relationship. The relationship cases present two distinct problems, that of the party relative and that of the attorney relative. Where it is the litigant who is a kinsman, the proximity of the relationship is the decisive factor in determining whether disqualification is necessary. Brothers, uncles and cousins merely begin the possibilities, for the judge's relatives by marriage may also appear as parties. The English view that judges might hear cases brought by relatives was quickly abandoned in America by statute, but these laws vary widely in prescribing the degree of relationship necessary to exclude a judge from hearing a case. 43. Of far greater consequence in the law today are the cases in which the attorney, rather than the party, is the possible object of nepotism. In a substantial number of jurisdictions the relationship of the attorney is not per se grounds for disqualification. The common law admitted of no such disqualification, and statutes frequently confine disqualification to cases in which the parties are related. In most jurisdictions, therefore, a judge need not disqualify himself unless the attorney can be considered a party. The question of whether or not the attorney is a party is often, but not always, 44, made to depend on whether or not he receives a contingent fee. If he does, or if his fee is set by the court, the judicial relative is disqualified in many jurisdictions. For the opposite result is usual where the fee is not contingent. 4 This practice lends itself to the drawing of some exceedingly fine lines. Thus in Mississippi a judge is disqualified if his kin receives a fee fixed by a percentage of the recovery by his client, but not if he receives a lump sum contingent upon his prevailing in the cause. 47. The problem of attorney relationship is further refined by introducing a distinction between cases where the relative personally participates and those where he is merely associated with a law firm appearing before the judge. The latter situation was recently denied as ground for a retrial by the Second Circuit Court of Appeals on the theory that the trial judge had in no way abused his statutory discretion. The court, however, noted that the question had not been raised until after the trial had been in progress for 9 days, and remarked that the judge would doubtless have disqualified himself had he sooner been aware of the plaintiff's objection to his sitting. 43. There is an increasing tendency in the Supreme Court for justices to disqualify themselves in cases argued by relatives. Solicitor General Hughes resigned when his father took office, and Chief Justice Stone would hear argument by his son only upon the consent of the parties. 42 19th century practice appears to have been less strict. Apparently no objections were made to the practice of Justices Curtis I and Field, who, on various occasions, sat in cases presented by their respective brothers. Similarly, Justice Miller heard his brother-in-law and close friend, W.P. Berliner, in at least 2 cases. 52 It is quite possible that at least in those jurisdictions where judges are plentiful and cases may be conveniently transferred from one docket to another, the attorney-judge relationship will be increasingly considered a basis for disqualification. Opinions of New York Bar Associations, 53, as well as a recent Delaware incident, foreshadow such a trend in state courts. That the same may be true of federal courts is indicated by a resolution of the Judicial Conference of Senior Circuit Judges in 1942. 5. Bias. Disqualification for bias represents a complete departure from common law principles. Despite Blackstone's denial that bias could exist as a ground for disqualification, a more recent humility has prompted recognition that human judges may deny justice not only for profit or to benefit a kinsman, but for less tangible prejudices for or against a party, a lawyer, or a cause. Although in many states a party cannot charge bias and thereby have another judge assigned to hear a case, the development is toward that end in the trial courts. This tendency is exemplified by the increasing popularity of 2 basic statutory devices. The first is an extension of the usual statutory grounds for disqualification to include additional situations where, in the opinion of the legislature, a likelihood of judicial partiality exists. The second is in the form of disqualification by affidavit, which amounts simply to mandatory change of venue at the request of either party. Affidavit statutes sometimes require the party requesting the change to establish grounds indicating bias, while in others a simple affidavit without supporting evidence is sufficient to effect a transfer of the case. 17 Although some affidavit statutes have been held unconstitutional as encroachments upon judicial power, 18 they are generally accepted without question. 1. The more significant situations involving possibility of judicial bias may, for convenience of analysis, be classified into those arising from the judge's attorney contacts, his party contacts and his government contacts. 60 Although the judge's relationship with his former law partners is logically a part of the first category, the public interest stimulated by the Jackson Black controversy has made its separate consideration in a later section seem desirable. A judge, of course, is often closely associated with attorneys not in the ex-partner class. Close friendships formed at the bar with other practitioners naturally outlive elevation to the bench. 61 And, presumably, if the ex-practitioner judge is intimate with former partners, the ex-teacher judge is equally intimate with former faculty colleagues. The ex-law clerk occupies a position not unlike that of the former junior associate. And an even closer association is found where a judge resigns from the bench and later appears before his former judicial colleagues. None of these grounds, however, is usually considered sufficient to warrant disqualification. For example, Justice Frankfurter does not disqualify himself when his former Harvard colleague and good friend, Paul Freund, is of counsel. 62 Nor does Justice Douglas decline to sit when he finds the names of his old Yale associates Thurman Arnold, Abe Fortas, and Walton Hamilton on briefs. 13 Moreover, Justice Rutledge has frequently heard oral arguments by Ralph Fuchs, a former associate at Washington University. Indeed, no one has ever suggested the desirability of disqualification in such instances. In the United States Supreme Court, ex-law clerks are barred from appearing before the court for 2 years after they leave the employ of the justices, a rule which suggests that the prejudicial effects of close association wear off rather quickly. 5 Few other courts limit in any way the practice of ex-law clerks. C. The ex-judge may well be the most intimate with the court of any of the exes, for his association has been not merely with one judge but with the group. Thus, on the theory that association breeds intimacy and intimacy breeds influence, Argument by a former judge might disqualify an entire bench. But the notion has never been pushed to that extreme, and in the United States Supreme Court, for example, ex-Justices Curtis, Campbell, and Hughes often appeared before their former colleagues. 7. The most difficult situation, and one which permits no rule of thumb, is disqualification in cases argued by an intimate personal friend. All judges have close friends at the bar, and perhaps on rare occasions a judge might be swayed in his decision by the presence of such a friend in court. Nevertheless, the overwhelming American practice is against disqualification for this reason. Although occasionally a judge does feel bound to disqualify himself, judicial response to the inquiry indicates that in almost half the states and federal circuits there is occasional disqualification for the reason of intimate friendship with counsel. 8. It is, for example, well known that Judges Learned Hand and Jerome Frank of the Second Circuit Court of Appeals avoid sitting in cases presented by certain close friends. A second possible source of bias is the judge's party contact. The propriety of a judge's sitting on a case involving a former client seems to depend upon whether or not the case in question was in his office prior to his going on the bench. When the judge has had prior contact with both the client and the case, disqualification is universal for the obvious, but seldom articulated, reason that a judge would seldom have an open mind under such circumstances, and to sit would invite charges of corruption. But where the judge's firm has been retained subsequent to his elevation to the bench, a closer question is presented. Reference to current practice discloses a dominant view that judges should not disqualify under such circumstances, but it is reasonable to suppose that the practice in any given situation may depend upon the nature of the case and closeness of relationship with the client. 10. Despite the opinion of the late Chief Justice Stone that disqualification in cases involving former clients is desirable, 71. The practice of Supreme Court justices has been to sit in such cases. Justice Roberts, for example, was a director of the American Telephone and Telegraph Company and counsel for the Pennsylvania Railroad before his appointment to the court, but subsequently participated in decisions involving both. 72. Similarly, Justices Lurton and Van Deventer occasionally passed judgment on their former clients. 73. A judge's former government contacts present a third possibility of grounds for bias. The young lawyer with political ambitions follows a familiar path to fame. A prosecuting attorney to begin with, election to the legislature or Congress, perhaps a stopover in the executive branch of the state or federal government, and finally a judgeship. The present Supreme Court affords several examples. Chief Justice Vinson has served in both the executive and legislative branches of government. Justices Burton and Black were senators, and Justices Reed, Murphy and Jackson have held executive positions, including variously the Solicitor Generalship and the Attorney Generalship. Justice Douglas headed the Securities and Exchange Commission, while Justice Frankfurter was once an assistant United States attorney. Only Justice Rutledge held no previous federal non-judicial post. It is, of course, possible that any of these past experiences may influence the judge in a case involving personalities and problems with which he has had prior contact. A judge might disqualify himself for bias because of his government experience. 1. If he participated personally as a government lawyer in the case under consideration. 2. If the case is presented by his former government associates. 3. If he participated in formulating the policy which the case involves. And 4. If he is a former legislator and the case involves construction of a statute he supported. That the same man should not assume the roles of prosecutor and judge at different hearings of the same case needs hardly to be said. The impropriety is obvious, and prosecutors who become judges almost invariably disqualify themselves in these situations. The case of the Tennessee prosecutor who, after his election as trial judge, sat on the retrial of an action originally instituted by him is exceptional, and reversal in that case was swift. 74. But there is no impropriety where the judge's role as prosecutor has been largely formal, as in the case of attorneys general, who have only theoretical responsibility for minor cases in their departments. Thus, although the Schneiderman denaturalization case 11 was in the Department of Justice during Justice Murphy's tenure of office as Attorney General, he presumably had no direct connection with it and felt free to vote against the department he had formerly headed. On the other hand, Justice Jackson, who succeeded Murphy as Attorney General, felt sufficiently involved in the same case to disqualify himself. But Justice Jackson, too, has, on other occasions, recognized that his previous contact with the matter was too slight to be prejudicial. Although as Attorney General he decided not to institute litigation concerning coverage of the insurance industry by the antitrust laws, he nevertheless felt free to participate in the decision of a subsequent action on the subject begun by his successor, Mr. Biddle. 76. Supreme Court justices have not hesitated to hear their former government colleagues. Again, current examples are furnished by the practice of Justices Murphy and Jackson, who regularly sit on cases presented by their former associates in the Justice Department. Although Supreme Court practice in this respect has evoked no criticism, there is a minority view in the state and circuit courts which regards presence on the bench as inappropriate under such circumstances. As the inquiry shows, the problem appears to have arisen in only about half the state and federal courts polled. When a judge has been involved with a case or its underlying policy in a capacity other than that of prosecutor, there is precedent in the United States Supreme Court for the view that he may sit. Chief Justice Marshall wrote the opinion of the court in Marbury v. Madison 78, although he was the Secretary of State who had failed to deliver the papers in question, and Chief Justice Chase voted to invalidate the legal tender laws which were the basis of his own fiscal policy as Secretary of the Treasury. 9. But responses to the inquiry indicate that many state judges take a different view. The ex-legislator, as state judge, may occasionally pause to consider whether he may interpret statutes he supported in his former capacity, but federal judges have no hesitation in participating under similar circumstances. An explanation for this divergency in practice may be found in the fact that federal judges are so regularly appointed from Congress that disqualification for this reason might paralyze the entire judicial machinery. 3 members of the present Supreme Court are ex-congressmen, and 25 out of the 75 appointed prior to 1937 had served in the legislative branch. So far as is known, Supreme Court justices have never disqualified on this ground, and other federal judges have very seldom done so. State judges, on the other hand, are more nearly divided as to the proper practice. While this problem has not arisen in a majority of the states responding to the inquiry, there is a variance of views in those in which it has. It is apparent from the foregoing discussion that the Supreme Court is less inclined to disqualification than some of the state courts. In an appreciable minority of states, judges disqualify themselves if a case is presented by a former government associate, if a judge participated in formulating the policy involved in a case, or if a judge is a former member of the legislature which passed a statute N6W presented for judicial consideration. Yet the Supreme Court practice appears invariably to the contrary. Similarly, no case is known in which a Supreme Court justice has disqualified himself because an intimate friend presented the argument, although in almost half the states responding to the inquiry at least occasional disqualification occurs for this reason. Explanation for this discrepancy may be found in the impossibility of obtaining substitutes for Supreme Court justices and the importance of having issues of national consequence determined by the full court whenever possible. If disqualification came too easily and justices frequently declined to sit, the entire federal judicial machinery might be seriously handicapped. Within the past 5 years, 3 instances have arisen which serve to dramatize the result of numerous disqualifications. A statute provides that 6 justices are required for a quorum of the court, 12, and in 3 recent cases, or groups of cases, disqualification by 4 justices resulted in a loss of that quorum and made it impossible for the court to act. 83 Since one of these cases was a crucial antitrust case and another involved the constitutionality of the Public Utility Holding Company Act, a serious impasse resulted. Several bills were introduced in Congress attempting to solve the problem by reducing the quorum from 6 to 5, by calling upon a retired justice to sit in the emergency, or by some combination of these devices. 84 Congress, however, was unable to agree on any of these proposals, and the bill finally adopted disposed only of the antitrust case by referring it to the Second Circuit for decision. Chief Justice Stone broke the deadlock in the holding company case by withdrawing his disqualification, but the third case had to be dismissed for lack of a quorum. Statutory disqualification of district judges. The two basic federal disqualification statutes, Sections 20 and 21 of the Judicial Code, 85, apply only to the practice of district courts. Section 20, dating from 1792, permits disqualification, if requested by a party, on four separate grounds: 1. Interest; 2. Previous representation of a party; 3. Prospective participation in the case as a material witness; and 4. Relationship or connection with a party. But none of the above situations presents an absolute ground for disqualification. A judge must disqualify himself only if circumstances will render it improper, in his opinion, to sit, and his determination is reviewable, if at all, only for abuse of discretion. Although for 120 years Section 20 remained the only important federal law on disqualification, its operative effect was sharply confined by judicial construction. Direct reference was made to the English common law for definition of interest, c, and this rationale restrictively applied to new fact situations. 3 has been of counsel was soon limited by addition of the phrase "in this case," and an attorney-client relationship prior to the case in dispute was never considered by itself sufficiently prejudicial to require disqualification. Disqualification of a judge on the ground that he was a material witness was confined to situations where the party could find no adequate substitute, 9, and the proximity of relationship required was held to be measured by the law of the state in which the court sat. 2. A statute so limited was not enough. The extreme discretion left in the trial judge, the narrow grounds for disqualification, and the complete lack of disqualification for bias were obvious shortcomings. Hence, when the Judicial Code was under consideration in 1911, Representatives Cashapp of Indiana and Shirley of Kentucky jointly persuaded Congress to add Section 21, the most significant federal disqualification statute now in force. Modeled directly upon the Indiana practice with which Cashapp was familiar, and revised on the floor of the House, Section 21 was intended to fill the need for a federal change of venue statute. Thus disqualification for bias and prejudice, excluded from the common law by Blackstone, finally found its way into the federal system in 1911. The statute provides that whenever a party files an affidavit affirming that the trial judge has a personal bias or prejudice against him or in favor of the opposing party, a new judge shall be appointed in a specified manner. The affidavit, however, must state facts and reasons to substantiate the belief that prejudice exists, and it must carry a certificate of counsel that it is made in good faith. A party is limited to one affidavit in a case and must file it within a prescribed time. The most serious question arising under the new statute was whether the trial judge 14 should pass upon the truth of the charges against his own qualification, or should automatically disqualify himself when the affidavit raising the issue complied with the statutory requirements. Initial doubts as to whether the statute was to be broadly or narrowly construed 11 were set at rest by Berger v. United States. The defendants in that case, charged with espionage, alleged that District Judge Landis was so biased against German Americans as to preclude possibility of a fair trial. Judge Landis phrased that one must have a very judicial mind, indeed, not to be prejudiced against the German Americans in this country. 91 lent considerable support to the claim. A majority of the Supreme Court held that the trial judge could do no more than make sure that the affidavit was legally sufficient, in compliance with the statute, and that its factual assertions were not frivolous. Under no circumstances, the court continued, should the trial judge pass on the truth or falsity of the charges. Perjury statutes and disbarment proceedings were sufficient safeguards against abuse of the privilege. The Berger decision, therefore, gave full breadth to the legislative intent behind the statute. Indeed, one may be more than a little shocked by the realization that for over a century of our history there was no statute which would make such evident bias a ground for judicial disqualification. But the clear Berger decision, the clear statute, and its clear legislative history have not been followed in practice, and federal trial practice still does not provide a litigant with the automatic change of venue to which he is apparently entitled upon filing an affidavit in good faith. frequent escape from the statute has been effected through narrow construction of the phrase bias and prejudice. Affidavits are found not legally sufficient on the ground that the specific acts mentioned do not in fact indicate bias and prejudice, a reasoning which emasculates the Berger decision by transferring the point of conflict. While lower courts do not assess the truth or falsity of the charge, a similar result is reached by holding that even if the facts stated are true, no prejudice is shown. Examples of such evasion are numerous. In a bankruptcy proceeding, an affidavit was filed by the Protective Committee charging judicial bias in favor of the General Electric Company, which had made a conditional sale to the debtor that the judge desired continuation of electric lines so as to prevent disaffirmance of the sale was supported by evidence that he had told the trustee he would not allow the committee's petition to set aside the sale, that he had requested the trustee not to testify, and that he had turned over documentary evidence relating to the petition to an officer of the General Electric Company without the knowledge or consent of the committee. The Second Circuit Court of Appeals held per curiam that the district judge satisfactorily explains his action and had committed no sin but that of indiscreet expressions, and hence was not disqualified. Another case held insufficient an affidavit which charged that a party had manipulated matters to have a case tried before a particular judge who had been given financial opportunities by an associate of the party. 100 Similarly, a judge alleged to have expressed himself in condemnatory terms of a affiant searched the evidence and concluded that the statement made could not by any stretch of the imagination be considered as giving any evidence of any personal feeling on the part of the court toward the affiant. Although he disqualified himself as a matter of discretion, he denied that he was compelled by the statute to do so. 101. An analysis of the cases leads to the conclusion that unless and until the Supreme Court gives new force and effect to the Berger decision, the disqualification practice of federal district courts will remain sharply limited. 102. While Section 21 of the Judicial Code may appear to provide a federal change of venue statute, it has not in operation attained this result. Judges and ex-partners. Cases in which judges come into contact with former partners can be divided into those in which the case presented by a former partner was in the office at the time the judge left the firm, and those in which the case arose after the judge had severed his partnership connection. The Jewel Ridge case falls into the second category. Portal-to-portal pay cases did not come to Justice Black's former partner until at least 16 years after dissolution of the partnership. Judicial practice in both these situations is clear. Judges invariably disqualify themselves when the case was in the office prior to dissolution of the partnership. 103. Otherwise it is the common practice to sit in cases argued by ex-partners. 04. Indeed, in the entire literature on disqualification, some 2,500 cases and 60 articles, not a single instance has been found in which it is suggested that ex-partnership, by itself, should be a ground for disqualification. 11. Similarly, no mention of this basis is made by the American Bar Association in its Code of Judicial Ethics. If a judge is to be disqualified from hearing cases argued by a former partner, disqualification must be founded on the theory that the previous association creates an intimacy which causes the arguments of counsel to have excessive weight with the judge. The difficulty with this argument, however, is that it is almost impossible to draw any rational distinction between the relationship of a judge with a former partner and that with a former faculty colleague, a former government associate, a former law clerk, a former bench associate, or simply an old friend. As has been noted above, these relationships are almost never treated as grounds for disqualification. The practice of Justice Holmes on the Massachusetts Supreme Court may be taken as one measure of the attitude of a sensitive justice in his relations with ex-partners. A study of a dozen volumes of the Massachusetts reports picked at random from the period of Holmes' tenure shows that his principal legal associates before going on the bench, George Shattuck and 4A. Monroe, 07 appeared before him no less than 9 times. During this period it seems to have been normal practice in the Supreme Judicial Court for 5 justices, rather than the full bench of 7, to hear most cases, and Holmes could, therefore, have absented himself had he desired. 10.9. In hearing cases presented by ex-partners, Holmes followed standard Massachusetts practice. Precedent was set by Lemuel Shaw, the great early Chief Justice of Massachusetts, who, Though associated with Sidney Bartlett for 10 years prior to being appointed to the bench, twice heard cases in which Bartlett was counsel. In the 12 volumes of Massachusetts reports studied, there appear at least 18 instances in which members of the Holmes Court sat in cases argued by former law partners. There is much evidence that justices of the United States Supreme Court have taken the same view. Justices have repeatedly heard arguments by former partners where the case in question was not in the office at the time of termination of the partnership, and not a single instance of disqualification for this reason has been uncovered. While there may be exceptions, data of this nature is almost impossible to search out systematically. It is certainly true that an overwhelming number of cases support Justice Black's practice. Examples illustrative of Supreme Court custom in this respect are numerous. Justice Field sat in cases argued by David Dudley Field, his brother and living companion, and also his former law associate. 112 Justice Harlan heard his former partner and close friend, Benjamin Bristow, on at least one occasion. 113 and Justice Pierce participated in denying certiorari in a case presented by his former firm. 114 Similarly, Justice Blatchford seems to have seen no impropriety in hearing cases argued by an ex-partner. 5 Justice Brandeis did not disqualify himself when his former associate, Edward F. McLennan, appeared before the court. 116 Almost exactly the same amount of time intervened between the termination of the Brandeis-McLennan partnership and the latter's argument in court as had intervened between the Black-Harris partnership and the Jewel Ridge decision. The former partnership had, moreover, endured for a much longer time. The practice of Justice Cardozo in hearing argument by his former associate Walter Pollack also supports Black's position. Pollack, who graduated from a law school in 1910, was in the firm of Cardozo and Engelhard from 1911 to 1914. As a young man he formed an intimate friendship with Cardozo which lasted until death. Despite his youth, Pollack achieved almost instantaneous distinction in New York and is credited with having managed Cardozo's selection for his first judicial position in 1914. 7. On many occasions thereafter Pollack argued for the firm, then Engelhard and Pollack, before Judge Cardozo on the New York Court of Appeals. 8. And after the latter's appointment to the United States Supreme Court, Pollack was counsel in the 2 Scottsboro cases. 119. Precedent in the Supreme Court would, therefore, seem to indicate that Justice Jackson's position in criticizing his colleague is at best tenuous. But, says Justice Jackson in his letter to the congressional committees, there is an exception. I pointed out that to imply approval of his sitting would put the court, and especially the Chief Justice, in a most inconsistent position. At that very moment the court was disabled from hearing an important case because Chief Justice Stone declined to sit for the reason that the case was being presented by his former law partners, although he had not been associated with them for many years. The North American Company and SEC versus Engineers Public Service Co. 123 years before, however, Chief Justice Stone had given his own public explanation of why he did not choose to participate in the North American case, and the reason he gave before the same congressional committee to which a copy of the Jackson letter was addressed was wholly different. According to his own statement, the Chief Justice felt disqualified not because of a former relationship with North American's counsel but because North American itself was a former client of his. After Congress refused to reduce the statutory quorum, the Chief Justice withdrew his disqualification and in fact did sit in the case. 122. Furthermore, in several other cases arising both before and after the Jewel Ridge case and before the Jackson letter, Stone did participate in decisions, though Sullivan and Cromwell, his former firm, was counsel. 123. The practice of state Supreme Courts and Federal Circuit Courts is substantially in accord with that of the Massachusetts Court at the time of Holmes and of the United States Supreme Court, although judges responding to the inquiry without exception disqualified themselves when a former partner presented a case which was in the office on termination of the partnership. More than 80% of the state and federal courts reporting a yes or no answer do not disqualify merely because the attorney in a case is a former partner. Conclusion: so general a subject and one with so many facets as disqualification scarcely permits of any conclusion more rounded than the obvious one that the law grows apace. There is near unanimity of opinion among courts as to the major situations which require disqualification on the founding ground of interest. In the newer fields of relationship and bias there is somewhat more division. The fastest growth today is in connection with relationship of judge to attorney, and there it may be noted that the trend has turned toward more general disqualification. The whole series of distinctions based on presence or absence of a contingent fee would seem at best a little silly. A reduction of the yes or no of disqualification to a level of grossness quite out of keeping with the real moral values involved. And the sooner law based on such distinctions disappears, the better. On the momentarily spectacular problem of hearing ex-partners, there is little that need be said when the evidence is in. Justice Black heard an ex-partner 20 years after termination of the association. In so doing he seems to have done pretty much what all judges do. Not a case can be found to say him wrong, and over 80% of the state and federal judges responding to the inquiry follow the same rule. Black's practice is at one with that of Justices Field, Harlan, Blatchford, Butler, Holmes, Brandeis, Cardozo, and Stone. Indeed, it is doubtful that any Supreme Court justice has decided this question differently. Had Black disqualified, he would have departed from the traditions of 150 years.